Senate will please come to order. Returning from a brief recess, and I believe the senator from Chittenden had the floor.
Madam President, I have no further statements around the questions that were already asked, and I believe the senator from Caledonia could perhaps remind me if there was a question that I hadn't answered yet.
Actually, Madam President, I thought that I had the floor and that I was questioning the presenter of the bill.
The senator from Chittenden requested a recess, so I was returning to her following the request, but the senator from Caledonia is now recognized.
Thank you, Madam President. And I thank the senator. Madam President, I've at least red flagged in my own mind a concern that there needs to be a little more conversation about these specific provisions. I have been assured that before third reading, there will be some more conversation with the appropriate parties. I plan on voting no just to preserve my issue at this stage of the game and reserve my right to change my mind before third reading. Thank you.
Thank you. The question is, shall the Senate amend the bills recommended by the Committee on Government Operations as amended? The senator from Franklin is recognized.
Thank you, Madam President. May I interrogate the reporter of the bill?
You may.
The Section 4 of the bill calls for a study of deceptive and coercive methods of law enforcement interrogation. Are there coercive methods of interrogation currently being used in Vermont?
So, Madam President, what we heard from the Police Academy and the Vermont State Police was that they generally try to shy away from these practices, that they generally use, I believe, what's known as the peace method or peace technique. And, you know, that has been deemed something of a best practice around interrogation. They try not to introduce false information or deceptive information in an interrogation. During the course of our discussion, as we were probing into all possible ways that coercive or deceptive information might be used, it was brought to our attention that there is local law enforcement being trained in the Reed technique as an example. We looked into the Reed technique as a committee, and as I mentioned in my previous report, it's a technique that's been banned in many Western European countries, and it's a technique that has it ended up being used in cases that have been thrown out for creating a false or deceptive climate in which an involuntary confession was then elicited. As I also said, this is even more likely when you're dealing with a juvenile and presenting false information. But I understand of the Reed technique, and I can, before third reading, get a more detailed outline of the 10 steps of the Reed technique. But that technique starts with taking any evidence that the investigator has and putting it in sequence and a potential full narrative, presenting a narrative to the person being interrogated about the way they committed the crime, and then asking them to confirm the motive by which that investigator had just put together the totality of the narrative about the guilt of that person. That is an incredibly subjective and suggestive way to interrogate a witness, and has been deemed not to be a best practice by our state police. At the time that we were discussing the matter, we learned that a local law enforcement agency in the state was advertising training in the Reed technique publicly, and it had been further advertised by our Criminal Justice Council without perhaps knowing that had been deemed not to be a best practice by our state police. So we believed that there was enough evidence of concerns that should be probed deeper around whether or not coercive and deceptive practices are being used in custodial interrogations in Vermont to merit a report back to our committees of jurisdiction.
My question was on coercive techniques as opposed to deceptive techniques. I'm very familiar with the Reed technique, having learned it more than 35 years ago, and having, as a polygraph examiner, conducted literally thousands of examinations and interrogations using, to some extent, the Reed technique. Deception is often a part of the technique, but I'm interested in what, if anything, do you know about coercion? Did you take any testimony regarding coercive methods being used in Vermont?
Madam President, before third reading, I could try to get a better definition of what's considered coercive, but the committee defined these types of interrogation that might elicit an involuntary confession as ones where false evidence may be introduced or a promise of leniency might be offered that was not necessarily based on fact, or you might introduce information that someone else has presented evidence or has, confessed to the crime. We wanted to look further into when and where these tactics might be used that one might define as coercive to produce an involuntary confession. I may not be meeting the senator from Franklin's definition of what he considers coercive, and I appreciate and understand that. And perhaps we can land on a better understanding of our shared definition before third reading.
Was there any testimony as to false confessions being obtained in Vermont by Vermont police agencies?
Madam President, that is essentially the reason for the study and for, in many ways, not moving forward with a ban. I would imagine that law enforcement would have no problem with a ban if they felt that they had a clear definition of what was considered coercive or deceptive, and we're not using that. As I referenced before, outside of custodial interrogations, law enforcement, did say that if they are trying to, for example, catch a child predator, they may pose as a minor in the pursuit of that potential suspect. These kinds of questions and scenarios came up, and the committee determined that it was in our best interest to look into this practice. We are looking at states around the country that are trying to align with best practice around interrogation, because someone falsely confessing to a crime and ending up having their civil liberties taken away is as great a concern as ensuring law enforcement has all the tools available to do their job with best practices.
So as I understand it, it's of course obviously important to know that we're not obtaining false confessions, but there was no evidence presented to the extent that there were false confessions in Vermont?
Madam President, as I stated, there was evidence that coercive or deceptive techniques were being used in our state by local law enforcement in a way that we did not have full information around as we started discussing the bill and came to light during our testimony. And so it was compelling enough for the majority of the committee to determine that a study would be valuable to better understand how interrogation practices are currently being conducted from our state law enforcement and our local law enforcement.
In the testimony before the committee, I'm assuming you heard from law enforcement, such as from the agency of the Department of Public Safety. Were they in favor of this bill as it reads?
Madam President, I can get by third reading a clear statement from our Commissioner of Public Safety. I would not want to misrepresent his final perspective on the bill. He raised concerns, particularly around use of investigatory techniques that are deceptive, that are important in the course of their business, that we addressed by removing any language that would introduce a new legislative action and instead creating a study. So from my perspective, I believe we addressed all of the concerns raised by the commissioner and much of law enforcement, but I can get a more authoritative answer on that question before third reading.
Thank you, Madam President.
The question is, shall the Senate amend the bill as recommended by the Committee on Government Operations as amended? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you've amended the bill as recommended by the Committee on Government Operations as amended. The question now is, shall the bill be read for the third time? Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you've ordered third reading of S-250. We have on the calendar for action S-254. And act relating to creating, a private right of action against law enforcement officers for violating rights established under Vermont law. It was introduced on January 13th, referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as appears on pages 1292 to 1294 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of S-254.
S-254, an act relating to creating a private right of action against law enforcement officers for violating rights established under Vermont law.
Senator from Bennington, the chair of the Committee on Judiciary, is recognized for the report of the committee.
Thank you, Madam President. I'd first like to thank the four co-sponsors, of the bill with me. Ballant, Baruth, and Ron. This bill probably been the most difficult that the Judiciary Committee has faced this session. It's not been easy. And what we come to you with today is a watered down version. I'm not going to sugarcoat it. Madam President, the debate over whether Americans can sue individual police officers began more than a century ago. In 1871, statute first provided a legal path to collect damages from officers and other government employees who violate constitutional rights. The law at that time was commonly referred to as the Ku Klux Klan Act because the law was designed to allow freed enslaved people from racist government workers. In 1967, the United States Supreme Court ruled on a Freedom Riders bus desegregation case in Mississippi created qualified immunity. And the legal doctrine was strengthened in subsequent federal decisions, making it nearly impossible to challenge in court. Madam President, if I might, I'd like to read from a Washington Post article entitled "Dozens of States Have Tried to End Qualified Immunity."
May.
Police officers and unions helped beat nearly every bill. The months after George Floyd's murder, state legislators across the nation tried to undo a legal doctrine that makes it virtually impossible to sue police officers for violating a person's civil rights. Fueled by outrage over the actions of former Minnesota officer Derek Chauvin, efforts to eliminate qualified immunity seem poised to usher in a new era, empowering citizens who felt wronged by police. But then in state after state, the bill withered or were withdrawn or were altered beyond recognition. This article is from October 7th, 2021. At least 35 states' qualified immunity bills have died in the past 18 months. Madam President, the article further talks about the efforts failed amid multi-faced lobbying campaigns by police officers and their unions, targeting the legislators, many of whom feared public backlash if the dire predictions by police came true. Officers said they would go bankrupt and lose their homes. They said their colleagues would leave the profession in droves. While advocates of overturning the doctrine agreed that qualified immunity allows rogue officers to brutalize citizens without paying a personal price, law enforcement officials countered that it protects police from being financially destroyed, the rapid life or death decisions they must make on the job. So far, Madam President, police are winning the argument nearly everywhere. State House battles have become even more important as qualified immunity changes have stalled out in Congress. The U.S. House passed the George Floyd Justice and Policing Act, which would restrict the use of the legal doctrine nationwide, but bipartisan Senate talks broke down last month, which was September of 2021. Madam President, the Connecticut Police Chiefs Association wrote a letter to legislators last summer threatening to withdraw support for the 65-page bill if a ban on qualified immunity wasn't removed, saying it will destroy our ability to hire and recruit and retain qualified police officers. The article further goes on to talk about some of the situations in other states where politicians have been attacked or sponsoring such a bill. If I might, I'd like to read from an article by Don Keeneland from Arlington, Vermont. Don writes, and Don is a friend of the junior senator and myself. Senator Sears' recent statement on qualified immunity was one of the most disingenuous pronouncements I've ever heard from a politician. While Senator Sears made it his announcement, he was emphatic that the time had come to remove the U.S. Supreme Court legal doctrine of qualified immunity for police and that every cop should be held personally accountable for their actions. In the same breath, he stated he's always supported police officers and those in law enforcement. Maybe he should sit in on exit interviews. There might well have been a time when Senator Sears supported law enforcement, but that was in the past. He has now swung his support to the far left, and one can only wonder what he expects to receive. Madam President, that is not atypical of some of the response that your Committee on Judiciary heard regarding this bill. What your committee did was take hours and hours of testimony to try to understand better what the problem was in Vermont specifically, not in New Mexico or Colorado. The original bill was based more on Colorado law, but your committee heard a lot of testimony. Frankly, it was very confusing. One side said there's a problem, the other side said there's not a problem. One side said, if you do this, police officer will leave in droves, we won't be able to hire anybody. The other end, there was a constant reminder that other government employees have qualified immunity. That it's not just police officers. But I was reminded by other witnesses that police officers make life and death decisions every day. Police officers are in a different role, and I do have the utmost respect for police officers. But we first had to try to understand the scope of the problem in Vermont. And that led us to what you see in the amendment that appears on the calendar. And then we have another amendment to further clarify. I wonder if I might speak to both at the same time. But first, I think it's important to understand the current state. And before I go too far into that current state in Vermont, it's important to understand the difference, what happened and how we got to the so-called Zulo case. Mr. Zulo was driving his car in Rutland County. He's an African-American. He was stopped by a trooper, and during the stop, the stop was because in March of 2016, his license plate was covered by snow, which is fairly common in Vermont, by the way. But he was stopped, and the officer smelled a hint of marijuana, but found no evidence that Mr. Zulo was driving impaired. But because of the faint smell of marijuana, Mr. Zulo was asked if he would allow a search of his vehicle, and he refused. The officer then impounded the car and denied access for Mr. Zulo, who then walked 8 miles home in March. So, you know, I don't know what the weather was that night, but it was probably fairly cold to walk 8 miles. So based on that fact, Mr. Zulo sued the Vermont State Police, the agency. And the lawsuit sought monetary damages, alleging the trooper's conduct violated Article 11 of the Vermont Constitution. It's important to understand that Article 11 of the Vermont Constitution protects citizens against unreasonable searches and seizures. Article 11 provides that the people have a right to hold themselves, their houses, and papers and possessions free from search or seizure, and therefore warrants without oath or affirmation first made affording sufficient foundation for them, and whereby any officer or messenger may be commanded or required to search suspected places or to seize any person or persons, his or her or their property not particularly described or contrary to the right not to be granted. That's the Vermont Constitution. It's similar, but not as expansive, to the Fourth Amendment of the U.S. Constitution. So it's important to understand here we're only talking about Vermont law, the Vermont Constitution, not the U.S. Constitution and how it would have found. So in the Zulo case, that was based solely on the Vermont Constitution and not on the U.S. Constitution. So the first question the court had to answer was whether the state can be sued for damages for an Article 11 violation. This question raised complex issues for the Vermont Supreme Court of sovereign immunity and when the state can be sued under common law and the Vermont Tort Claims Act. The court held that under certain circumstances, civil lawsuits for damages can be brought for Article 11 violations under the Vermont Constitution. So that leads us to Zulo and the court's finding: one, the officer violated Article 11. There's no meaningful alternative remedy in the context of that particular case. And the officer either knew or should have known that the officer was violating clearly established law, or the officer acted in bad faith. A clearly established right is one that is sufficiently clear that every reasonable official would have understood that what he or she is doing violates that right. The court then applied the standard to each of the alleged Article 11 violations. The temporary stop of a vehicle is a seizure. The court was satisfied that the officer had reasonable suspicion of criminal activity, that is satisfied if the officer has reasonable suspicion of criminal activity. The state argued there was reasonable suspicion for the stop because of the obscure registration sticker. However, the court held that partially obscured registration stickers do not actually violate Article 11 at all because it did not obscure the numbers on the license plate. Since there was no traffic violation at all, there could be no reasonable suspicion of one, and as a result, the stop violated Article 11. And then the search and seizure of the vehicle. In contrast to a temporary stop, a search and seizure of an unconstitutional violation of Article 11, unless it's supported by probable cause. The state argued that the trooper was justified in seizing and towing Mr. Zulo's vehicle because the trooper had probable cause to believe it contained marijuana on the basis of a detection of the state origin marijuana. The presence of an air freshener and Visine in the vehicle, and Mr. Zulo's acknowledgement that he had smoked marijuana within the past few days. The court first noted that once the trooper no longer believed Mr. Zulo was driving impaired, all factors other than the faint odor of marijuana are no longer relevant to whether the marijuana was in the vehicle. That is the violation of Article 11. And as the court noted at the end of its opinion, it will be relevant to this determination that Mr. Zulo has consistently suggested throughout the proceedings that the trooper's stated reason for actions were driven by implicit discriminatory basis. This is because the court made clear a claim for damages based on the officer acting in bad faith could be made by showing the officer acted with discriminatory bias. This is a very significant result of the decision that when an officer is acting out of discriminatory bias, violates a person's constitutional search and seizure rights, the state can be sued for damages under Article 11 of the Vermont Constitution. So what you have before you as the amendment or the amended bill is trying to incorporate Zulu into Vermont law. And because in the opinion of some, Zulu does not cover all police agencies, only the state of Vermont or the Department of Public Safety. So for example, this bill codifies Zulu and applies it to each police agency in the state of Vermont, whether it be the University of Vermont Police, the Bennington Police Department, or the Capitol Police Department. All police come under the same standard. And that's simply what we've tried to do. So what you'll be voting on, if you approve the amendment, is not to take away qualified immunity. It is simply allowing people under Article 11 of the Vermont Constitution to sue police agencies, not individual police officers. This does not end qualified immunity. Many of us wish it did, but it does not. This is the result of extreme compromise in your Senate Judiciary Committee, and I'm happy to go over. Do we do the amendment first, Madam President?
We'll take the first amendment, we'll vote on that, and then I'll come back to you for the second amendment.
Okay. So should I just, I'm confused if the amendment that was just handed out from Senator White and Sears, is that the first one or is it the second?
I believe the first one is in the journal for today.
Oh, okay. Well, we have an amendment that attempts to clarify what is in today's journal. I mean, today's calendar and journal. So I'm going to, if it's okay with you, Madam President, I'd like to talk to both amendments at the same time. It might become confusing if I don't, if I haven't already confused everybody. So S-254 is amended. Committee report strike all and the floor amendment proposes to codify the principle established in the 2019 Vermont Supreme Court decision of Zulu v. State and apply it uniformly to actions to recover damages, the legal term for money, against any law enforcement agent in the state of Vermont. It also creates a requirement that law enforcement agencies maintain a record of all judgments or settlements paid. Finally, the amendment commissions a report to review the state of qualified immunity in Vermont and any impediment to civil justice that it presents. Before I get into the details of the again, as I said, it's important to understand that despite prior versions of the bill, this bill does not eliminate the defense of qualified immunity available to law enforcement officers, plain and simple. The Vermont Supreme Court decision on Zulu is based solely on the Vermont Constitution. So what the amendment requires for a claim under Article 11 of the Vermont Constitution is a law enforcement officer violated Article 11. That's the first finding that a plaintiff must prove. The second is that there's no meaningful alternative remedy in the context of that particular case. And the third is the officer either knew or should have known that the officer was violating clearly established law or the officer acted in bad faith. I want to define bad faith, if I might. Third part of the Zulu principle is significant because it incorporates bad faith as part of the standard that Vermont courts consider. Bad faith is characterized by ill will or wrongful motive, including discriminatory animus. This was a rejection of the U.S. Supreme Court's approach under the Fourth Amendment, since the court held that an officer's bad faith, the Supreme Court held, U.S. Supreme Court held an officer's bad faith is irrelevant if there's other natural and reasonable basis for the search and seizure. With these things in mind, S-254 provides clearly clarity and uniformity by applying the principle to any law enforcement agency in Vermont, excuse me, for alleged violations of Article 11. And that, Madam President, is basically what is in front of us. There is a study and the amendment that will follow after we vote on the first amendment. I will discuss when that comes up.
Okay. I need to confer with the secretary just a moment longer because I believe the handout includes both the first and the second amendment.
Yes.
And I just, do you want to additionally report
Yes.
other portions of the amendment and then we'll vote fully on this amendment?
Yeah.
Sorry for the confusion.
I hope.
I think we're now all on the same page.
Right. The first, second, and third amendments that were handed out today are clarifying. The first amendment clarifies that the committee's intent is to have common law principle established in Zulu v. State apply uniformly to any law enforcement agency in the state actions alleging a violation of Article 11 of the Vermont Constitution. The aim of this amendment is just to add clarity to what is contained in the committee report. The second instance of amendment creates a new subsection, B, and it would enumerate the Zulu principle again for clarity. This instance of amendment is to ensure that the law would apply for alleged violations of Article 11 against a law enforcement agency. And the third instance of amendment is another one aimed at clarifying, it clarifies the report on access to civil justice remedies and law enforcement qualified immunity in Vermont is confined to legal analysis and does not make policy recommendations. Important that we understand the Office of Legislative Counsel is not in a position to make policy recommendations without legal analysis. This amendment was reviewed by the committee this morning, and all four members of the committee supported this amendment, although two members of the committee do not support the bill and would continue to not support the bill. So it's important to understand that while you might vote for this amendment to make the bill better, some senators may still vote against the bill. Hope I've clarified, and I'm happy to try to answer questions.
The question is, shall the Senate amend the report of the Committee on Judiciary as recommended by the senator from Bennington? Are you ready for the question? The senator from Caledonia is recognized.
Madam President, this seems like an ideal time to do two things. First, rise to the defense of the senator from Bennington because he was the recipient of some comments that were totally uncalled for, usually from people who have no concept of what was actually being discussed in committee. I can assure you, Madam President, that the chair of our committee does everything he possibly can to try to understand arguments from both sides, to come up with something that is consensus-oriented. And while he and I sometimes disagree on which one of us is making the right decision, I want to assure you, Madam President, that he has never left unturned any stone that needs to be discussed. I voted against the bill in committee, one of the two. I want to talk about this amendment, however, that is before you now. This is a classic example of the senator trying to reach consensus on this discussion. I think that it is doing two things that are important. For that reason, I will vote for the amendment. First, the Zulu case that has been the topic of discussion dealt with a fact-specific scenario involving one state police officer. The lawsuit was targeted solely at the state police, not other law enforcement agencies. And the ruling that had been made by the court, as I understand it, was that the Supreme Court had a concern that it had not received direction from the legislature as to whether or not the decision it was issuing should be applied to all law enforcement agencies, not just this one. And so they basically kind of left a hint saying, legislature, why don't you clarify this? I believe this amendment does clarify that by expanding the list of entities that can be sued under qualified immunity. The second part of this is very important in my eyes because it's calling for a report, which I would very much like to have in hand prior to voting on the bill that will eventually be before me. It's kind of a cart before the horse conversation in my eyes, and I'd like to have that report to figure out exactly what is the problem that we are looking at, and I'm not comfortable that we have got to that point. Now, having said all of that, I may stand up again when it comes time to talk about the bill. Promise to be short, but I want to assure people that the reason that I'm voting for this amendment is because it does attempt to clarify things that do need to be clarified. It does ask for information that we need to have. Thank you, Madam President.
Question is, shall the Senate amend the report of the Committee on Judiciary as recommended by the Senator from Bennington? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay.
Nay.
Ayes appear to have it. The ayes do have it, and you've amended the report as recommended by the Senator from Bennington. The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary as amended? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes appear to have it. The ayes do have it, and you've amended the bill as recommended by the Committee on Judiciary as amended. And the final question is, shall the bill be read for the third time? Are you ready for the question? The Senator from Caledonia is recognized.
Madam President, just to clarify, I remain opposed to the bill in toto for a couple of reasons. First, when it was originally presented to us, it came to my belief that the presenters were claiming people were not getting a remedy as a result of qualified immunity. Qualified immunity was not born in a vacuum. There was a rationale behind why it was created, and it has served actually quite well for a very long period of time, except for the pocket from which you get immunity. There are people who were using the George Floyd situation as part of the conversation. And the issue of what's known as the 1983 civil rights violation. I want to be clear, this bill does not correct a 1983 civil rights violation problem because that is a federal issue and not a state issue. Secondly, people were not prevented from getting a remedy. They are prevented from getting a remedy from a specific pocket. And using the George Floyd case as an example, the folks who brought suit, representatives of his family, actually could not sue individual officers. And I share a concern that that is the case. In fact, they could sue the municipality, which they did, and were awarded $47 million. I don't think $47 million is adequate in that situation, but it would be disingenuous to suggest that they did not receive a remedy, that we were going to somehow cure that with this bill that was in front of us. Finally, Madam President, I was very sympathetic to law enforcement who made a very good argument about the fact that there are severe problems recruiting people in the midst of a period of time where people are calling for defunding the police, and curtailing all kinds of police conduct in bills that in toto sum up to say, we don't like police officers. And as a defense attorney, I found that objectionable, and for that reason, I don't think I can support it. Thank you, Madam President.
The question is, shall the bill be read for the third time? Are you ready for the question? The Senator from Windham is recognized.
Thank you, Madam President. As some of you know, this has been a really, really hard issue for me. Having worked with law enforcement for many years, I've come to better appreciate the difficulty of their job. Even the best trained and best meaning officer has to make split-second decisions that could result in life and death. I could list the issues, the policies, and the training changes and disciplinary changes that we have been implementing over the past few years, but I won't. If any of you have any questions about what we've done over the past few years, I'd be happy to talk to you outside the chamber. In fact, we just voted on even yet more reforms, and these reforms have been done in collaboration with law enforcement. I resent many of the allegations that have been made against law enforcement, painting them as the bad guys with closed minds. I know this is not true. They do not oppose improvements. They often initiate them and always actively engage and collaborate. We have absolute immunity. We do not have qualified immunity. We have absolute immunity. The concept of immunity is not the issue in my mind. The issue is how it is applied. And in Vermont, we have heard that the courts apply it in a reasonable manner. I'm sure there are those victims who have not been able to receive compensation because of qualified immunity, but there have been millions paid out by law enforcement agencies to victims over the past few years. And we have lists of some of those. So the real question in my mind is whether or not qualified immunity should be eliminated, but how it is applied in Vermont and how many people have in fact been denied compensation because of it. I was absolutely opposed to the bill as introduced. I believe that even this version has the optics of not trusting law enforcement, sending that message, and the negative impact that it has on our officers and our agencies. My fear is that law enforcement feels under siege, and this adds to that. Given my concerns, I appreciate the chair's willingness to come to this version. I have faith that the study will show that qualified immunity has not denied victims access to compensation, and that it will show that qualified immunity is reasonably applied in Vermont, and there is no need to eliminate it. So for that reason, I will support this version.
The question is, shall the bill be read for the third time? Are you ready for the question? The senator from Chittenden is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill?
May.
Thank you, Madam President. I'm just a little confused with the concept of qualified immunity versus sovereign immunity. And how is it that we are paying, or the state police or whatever, is even if they don't have the agency doesn't have qualified immunity, in these cases, has sovereign immunity been raised? I don't know if you can help me with that.
This bill really doesn't impact qualified immunity for police officers.
No, I know.
What has happened in the Zulo case was a test of, could you sue a state agency? Obviously, no, the state has sovereign immunity and can't be sued. But in this case, because of an Article 11 violation, the Vermont Supreme Court found that the agency of it's not an agency yet, the Department of Public Safety could be sued. And so the agency was sued, and I believe the settlement was $50,000.
So essentially, in this context, sovereign immunity and qualified immunity are merged into one concept.
Yeah, but the qualified immunity, this doesn't affect for the individual police officer. All this means is that if they unsure, what was left from the Zulo decision was, does the individual municipal police departments, sheriff's departments, and other law enforcement agencies, are they covered by the Zulo test? And I believe the Supreme Court in 4 or 5 different places, the Vermont Supreme Court, this decision sort of, they didn't come out and say it, they never do, but sort of asked, the legislature could weigh in here. And so what we're trying to do here is weigh in.
Thank you, Madam President.
The question is, shall the bill be read for the third time? Are you ready for the question? The senator from Windham is recognized.
Thank you, Madam President. I thank the chair of Judiciary, who has worked very hard for months to take up an issue that has not been examined closely for half a century. 50 years. And it is not, in my mind, outrageous to ask that we examine a policy that's been in place for so long that appears perhaps not to be serving the needs of all citizens. And when you look at Section 2, as in the calendar, it's a report on access to civil justice. That's what we're talking about. It's about people having access to civil justice. And Madam President, these issues are very hard for a lot of reasons. But I want to be clear that I don't believe that any of the co-sponsors on this bill sponsored this bill as an attempt to disparage anyone. This is about examining a practice that has not been closely examined for a very long time. Our police officers are meant to protect and serve. Protect and serve whom? All of us, the citizenry. And it is not outrageous to ask that after 50 years, we take some time to examine whether this is meeting the needs of the citizenry. Thank you, Madam President.
The question is, shall the bill be read for the third time? Are you ready for the question? Senator from Chittenden is recognized.
Thank you, Madam President. I would ask that my colleagues and those watching and listening to this debate take a moment to think about your first or any recent interaction with law enforcement that you've had. How old were you? Do you feel that the interaction was justified? Do you feel that you got off maybe better than you should have and you didn't face the same consequences that someone else might have? Did it traumatize you? Did it make you fearful for life of interacting with another police officer? Was your body touched? Did you lose your civil liberties and wonder if you would lose your life? If this chamber looked different, if this chamber was full of people of color or people with disabilities, the answers to those questions would be significantly different. My first direct interaction with law enforcement, not counting all the times that my brown-skinned father was pulled over while his kids were in the car for suspicion of a stolen license plate, suspicion of a stolen vehicle. The first time I interacted directly with law enforcement, I was 13 years old. The first two questions I was asked are you Mexican? And are you sure you're not Mexican? It sounds funny, and yet that is a very, very common experience for someone who looks like me in America. My friend and I were told a half a block away from her home on a school night that we were breaking curfew and we needed to be taken to the police station. The police station was 45 minutes away, where we were handcuffed to a bench for most of the night without access to a phone, without the ability to call our parents, and without any access to legal information or any information at all. Very late in the night, a law enforcement officer came over to the two officers who had detained us that evening and said, "Don't you think it's a little late to have these young women here on a school night?" That was a defining moment in my life because I thought, wow, there are such things as good police officers who will come fix a bad situation where officers have done something wrong. The two officers that detained us said, "It's okay, we're getting overtime." All of the officers had a good laugh, and that officer that I thought would remedy the situation when I was 13 years old walked away. And that's when I learned that there is no amount of money in the world, not $47 million, no amount of money in the world that can heal the trauma of that situation, that can bring someone's parent back, that can right a wrong where you are traumatized and feel unsafe around law enforcement for the rest of your life. And perhaps because someone thought you were a criminal at the age of 13, you start acting like one. When I went into court and had to miss a day of school for that interaction, the officer asked me my name and my birthday, and many of you know I usually don't have a problem speaking up, and I could not get those words out of my mouth. I could have gone down a very different path from that experience, and unfortunately, it is the experience of so many Black and brown Americans in this country. And I know what you're thinking. That was Los Angeles. That's New York. That's Chicago. Well, I would like to remind the chamber that in Burlington, studies have shown that almost as many Black teenagers are arrested as white teenagers by the Burlington Police Department. And they are a fraction of the overall number of teenagers in Burlington. In Chittenden County, young Black men make up 2.5% of the youth population, and they make up 25% of those charged as youthful offenders in Chittenden County, 10 times their representation in the population. In Bennington, we know that studies have shown that 75% of all people pulled over are Black men. And in Brattleboro, you are 9 times more likely to be pulled over as a Black American than a white American. And so when we talk about what does this do to recruitment and retention, how do we make sure that we have a robust, robust law enforcement in our state, we have to also remember that this is culling talent, culling lives, culling people who want to live in Vermont. These disparities are vast. And these disparities make people say, why would I live in a state that treats me so inhumanely? Does this state believe that Black lives matter? When you look at the case of Greg Zullo, I ask you, if you had a 21-year-old who was a college student at Castleton University, and they called you from the side of the road in the middle of the night without a coat in winter because an officer had said there was snow on their license plate and took their vehicle away from them at the end of the interaction, would you want your child to stay in that school? Would you want your child to stay in that community? Would you want a remedy for your child that was more than a payout that took months, if not years, to get to in the Supreme Court? Would you want justice? That's what the original bill was asking for. And I understand and appreciate the compromise on this bill. But at some point, we will have to have a reckoning as a state as to whether or not we will let these deep disparities persist. We will let a culture continue and continue to pay out millions of dollars for that culture to exist. Whether we will ultimately decide that we can't rely on good officers to police bad officers, and whether or not we will look at a practice that is stealing civil liberties and stealing lives. And with that, I will support the bill, but I hope that this chamber will continue to ask these questions of itself. Thank you.
The question is, shall the bill be read for the third time? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay.
No.
Ayes appear to have it. Ayes do have it, and you've ordered third reading of S 250. I do have S 258 on the calendar next. I just want to confirm we should continue forward. Senator from Wyndham is recognized.
Thank you, Madam President. At this time, I think it makes sense for us to curtail our work here. I know that there's a lot of work still to be done by the money committees this afternoon, and I think we should wrap up our time.
They needed a motion. Senator from Wyndham is recognized.
Yes, I knew exactly what.
But it is Friday, the 18th. I think Tuesday is the 22nd.
Thank you, Madam President. Pending announcements, I move that the Senate stand in adjournment until Tuesday. Tuesday next, exactly, at 9:30. Thank you, Madam President.
The senator from Wyndham has moved that subject to any announcements, the Senate do adjourn until Tuesday, March 22nd at 9:30 a.m. And I believe that is a pro forma session. It is not. It is a session. Are there any announcements? Senator from Washington is recognized.
Madam President, Senate Finance will be 30.
Senator from Bennington is recognized.
Thank you, Madam President. Senate Education will meet at 1:30.
The senator from Caledonia is recognized.
Thank you. Senate Appropriations will meet at 1 o'clock. Bring your lunch. We have a lot of bills to get out.
The senator from Wyndham is recognized.
Thank you, Madam President. Government Operations will meet at 1 o'clock, and I know it's pushing it, but we have Congressman Welch on with a very, very short time frame, and he has to be on at 1 o'clock. Thank you.
The senator from Caledonia is recognized.
Madam President, Senate institutions will meet at 1:30.
Are there any additional announcements? The senator from Wyndham is recognized.
Thank you, Madam President. The Senate Rules Committee is going to have a very brief meeting at the fall of the gavel that the majority leader will be.
Thank you.
Right here.
Here.
In the
Okay.
chamber. Thank you.
Are there any additional announcements? Seeing none, hearing none, the senator from Wyndham has moved the Senate do adjourn until Tuesday, March 22nd at 9:30 a.m. for an official session. And hearing no additional announcements, are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay. The ayes have it, and the